Hello. In this clip from our Justia Webinar, How to Effectively Handle Long COVID Disability, Edward Dabdoub gives an overview of long COVID definitions and shares all of the common issues that arise when filing long COVID disability claims. Remember, if you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Good morning, everyone. Welcome. Thank you for that introduction, Nina. As Nina explained, we're going to be focusing the CLE on how to successfully handle long COVID disability insurance claims. And just want to say from the outset that we're focusing on insurance, not Social Security or other government benefits such as SSDI or VA benefits. So again, it's insurance claims with insurance companies, and specifically with a focus on ERISA, the Employee Retirement Income Security Act of 1974, which applies to the overwhelming majority of disability insurance claims nationwide. So with that background, I will move on to the next slide. And just to go over briefly what we're going to be covering, give an overview of the topic. We're going to begin with an explanation of what exactly is long COVID. We've been hearing a lot about it since the pandemic, but the CDC has a definition. Other reputable organizations have similar but varying definitions. So we'll discuss the CDC's definition, and then we'll look at what are some of the common symptoms, what are some of the unique problems these common symptoms present from a disability insurance claim perspective, what to do about that problem. And you know, those are some of the things. Like these symptoms are inherently subjective. They don't lend themselves very easily to traditional objective testing such as MRIs or X-rays, which disability insurance carriers like to focus on when making claims evaluations. And we will then move on to looking at just a few of the contract limitation provisions in long-term disability insurance policies. You know, what are the main provisions that insurance carriers are using to either deny benefits or as an exclusion, or to limit payment of benefits to either only 12 months maximum or 24 months maximum when you're dealing with medical conditions that arguably fall under the umbrella of fatigue or self-reported conditions. So we'll take a brief look at some of those contract limitations and then discuss how to get around that. Briefly, I'll talk about how ERISA takes already a pretty complicated case, claim and makes it more complicated. We'll look at some examples of denial rationales by insurance carriers. And then we'll dive right into how to make a long-term disability long COVID claim a winner, how to successfully challenge the insurance company, how to get these claims approved without having to file a lawsuit, and if you have to end up litigating the case, how to make sure you have what we call a winner in federal court, which is where you'd end up on these ERISA governed disability claims. And then we'll, time permitting, end with a brief look at some of the case law, and then I'll take some questions. So with that overview in mind, let's begin with the definition of what exactly is long COVID. And so the CDC's definition here on the slide is some people who have been infected with the virus that causes COVID-19 can experience long-term effects from their infection, known as long COVID or post-COVID conditions. And so it is broadly defined as the signs, symptoms, and conditions that continue to develop after acute COVID-19 infection. And so here we have a list of some of the common symptoms. And I want to point out that as you hear stories from prospective clients, you'll hear different people have different symptoms. That's one of the unique attributes of long COVID. It affects different people differently, but we see some amount of commonality in the symptoms, and here are the main ones that we've listed. Now, you'll note that the overwhelming majority of these, except one, is inherently subjective. And that's the unique problem with a long COVID disability claim. You are presenting to the insurance carrier a disability claim, knowing that these symptoms are inherently subjective and difficult to objectively prove. So that presents some issues, right? So one of the things we see insurance companies do is they like to lump any kind of condition that's based on fatigue, exhaustion, cognitive impairments. They like to lump these all as just fatigue conditions. And as we'll talk about a little bit later on the next couple of slides, this ends up limiting benefits to maybe 12 months, 24 months, depending on the insurance policy provision. As I mentioned, ERISA makes this worse. We'll talk about the subjective symptoms and why those are hard to prove, what to do about it. And complicated medical condition is that most clients have a hard time getting to a treating physician that actually understands long COVID and not just can provide appropriate medical care, but can help during the claims review process. And then finally, we know that the insurance companies, by and large, their medical reviewers do not understand and certainly do not specialize in long COVID. And most of them are not in the business of treating patients to begin with, but instead are careered medical reviewers for insurance companies. And so they may not either be up to date on the literature, and they certainly have no expertise by way of actually being hands-on in treating patients. And so there's a lot of misunderstanding coming from the insurance side. So here's a typical contract limitation I mentioned about chronic fatigue. But this one deals with a specific list of conditions that are limited to 24 months. We have 3 bullet points at the bottom of this slide: chronic fatigue syndrome, chronic fatigue immunodeficiency syndrome, Epstein-Barr syndrome, kind of all one of the same lumped together. Notice they all fall under chronic fatigue conditions. What we've seen sometimes is insurance companies try to rebrand long COVID as a chronic fatigue syndrome, right? Which is itself a distinctly different but very similar. In fact, to be truthful, it's hard to sometimes distinguish the two conditions. And there's a lot of research that's taking place in the medical field now that shows these are very closely related in some ways. And so insurance companies then like to take these long COVID medical conditions and kind of lump it under just generally a chronic fatigue type condition, thereby limiting payments to 24 months. Here's another one. These are the self-reported symptoms limitation. Many insurance policies have it. Unum, I believe MetLife, Standard. A lot of these insurance policies will limit payment to 12 months, sometimes 24 months for medical conditions that are primarily based on self-reported symptoms. Notice the definition of self-reported symptoms. It is the manifestations of your condition, which you tell your physician, right? That's self-reported, that are not verifiable using tests. Well, what types of tests, and who gets to determine if those tests are objective evidence or not? And they're not verifiable by procedures or clinical examinations findings. So, so someone cannot go into a physician's office and be examined and the physician says, yes, I noticed based upon this physical examination, you have a fatigue of 7 out of 10. You cannot be placed into an MRI or X-ray and you come back out and it says you have fatigue of 7 out of 10. You have all these other symptoms. You have cognitive impairment, etc., etc. So insurance companies like to take advantage of that scenario and say, well, there you go, self-reported, we're limiting payments if they don't outright deny it to begin with. So there are ways for us to combat these limitations and exclusions in the insurance policies. All right, what is ERISA? Just briefly, this is not a presentation on ERISA, but I believe the background is important. ERISA was passed in 1974 by Congress, and I think the intent was good. The intent was to encourage insurance companies to offer more insurance to the working class Americans through employers. So these are employer-sponsored health insurance, disability insurance, life insurance policies. Anyone who obtains any type of insurance through employment, that insurance policy and thus the claim would be governed by ERISA. What I've seen in my career, been practicing for almost 20 years, but certainly I'd say almost since ERISA was passed, and certainly since a landmark decision in 1989 by the Supreme Court called Bruch versus Firestone, what we've seen is a body of federal common law that has developed in a way that is fairly hostile to plaintiffs or disability claimants, specifically if it's governed by ERISA. And so what we're now up against is a situation where ERISA is unlike any other types of insurance claim. And here are just a few points, right? In a normal type of insurance case, you get to admit any evidence in a trial that is relevant to the question of whether your client meets the definition of disability in the insurance contract. Not necessarily so in an ERISA case. Most ERISA cases will be decided by cross motions for summary judgment. And we will have one of two standard of reviews that apply. You'll have a de novo standard, which is the court will just make its own finding based on the evidence. In most circuits, the court will still only be reviewing the documents and information in the insurance company's claim file. So there will rarely be any new evidence admitted to the court in litigation. And then you have what's known as an arbitrary and capricious standard of review. And this is where the court essentially tips the scales of justice in favor of the insurance company, affording the insurance company's decision to deny benefits, deny your client's appeal before the lawsuit was filed, unless you can establish that the decision was completely unreasonable. I've given below here an example from Unum, one of the insurance companies, what language is deemed sufficient to trigger discretionary review, to trigger that arbitrary and capricious standard. And if you have a case that is an arbitrary and capricious standard of review, you'll definitely be working with a closed record. You'll be litigating it. You'll be limited in the amount of discovery you can obtain from the insurance carrier. Again, this depends on the circuit you're in, but generally, limited discovery, certainly no jury trials, and most cases decided on cross motions for summary judgment. And you have a heavy burden to carry. So I think insurance carriers in these ERISA governed claims know they have an upper hand, and you combine this legal advantage with the inherent difficulties in proving up a long COVID disability, and you have a recipe for disaster for claimants unless you have a certain strategy to counteract all these things. And that's one of the things that's actually the main thing we're discussing today. Before we get into how to prove up long COVID disability claims, how to get those approved, I want to talk about what some of the denial language, the denial rationales look like. What are some of the things that insurance companies are saying? These are 4 excerpts that come directly from denial letters from our firm's clients. And you'll see variations of these, but by and large, they're all essentially saying the same thing, more or less. So number one, insurance company says the documentation does not provide valid or reliable evidence to support impairment related to cognitive deficits. Well, what is valid? What is reliable evidence to support impairment? Well, that's code by the insurance company to say, you didn't give us any MRIs, you didn't give us x-rays, you didn't give us, maybe blood work or some other laboratory testing that could objectively and validly show that there is impairment. They know those things don't exist. And so they know it would be unreasonable to come right out and say, well, you didn't give us MRIs or x-rays. So they package it a little bit differently, but that's essentially what they're saying. Second sentence there is the MMSE, Mini Mental Status Exam, is a screening tool and does not address etiology. Okay, doesn't address etiology. That's true. Now, by etiology, what the insurance carrier is saying is you haven't proven the cause of your client's impairment. That is a red herring. Don't go down that rabbit hole, because as I'll talk about a little bit later and I'll show some case law, we are not required to prove the etiology. We're not required to prove the cause of our client's disability, of their medical condition. No, instead we have to be able to prove that there exists restrictions and limitations caused by symptoms that are severe enough that result in our client's inability to work on a reliable and consistent basis. Number 2 on this list, here's another one. The medical records currently do not support evidence of a positive test results. And while it is known that COVID-19 infection can result in long-standing chronic neurologic symptoms, the level of care does not support your symptoms to rise to the level of impairment, nor does it support that your symptoms are from a neurologic etiology. They're just throwing up all sorts of stuff there, but essentially, right, they're saying there's no positive test result. And then they end with, and we don't know there's a neurologic etiology. So essentially, they're now, again, calling into question, do you even have this condition? You haven't proven that you have this condition. And then there's a level of care does not support your symptoms rise to the level of impairment. What does that mean? Well, is your client going to a doctor every 6 months? Okay, the insurance carrier may have a point, not enough care. But be careful. Be careful to get into that game with them, because the reality is a lot of doctors, they don't really have a great way of treating this condition. So what does level of care mean when doctors themselves haven't really fully figured out how to treat someone who is suffering from long COVID symptoms? We'll talk about that a bit later. And then number 3, here's a language. Given lack of evidence to support your cognitive complaints, right? Lack of evidence. Well, how do you prove cognitive complaints? We'll talk about that shortly. But that's kind of falling into the typical rationales we see. It's a lack of evidence. It's not reliable evidence. It's not objectively verifiable evidence. Number 4, the reported symptoms, right? That terminology, reported symptoms, that connotes, it conjures up like this perception that it's only self-reports. You have nothing by way of examination or diagnostic findings to confirm these symptoms exist, much less that they exist to a level that causes one to be disabled. So those are some of the typical rationales that we're seeing from all insurance companies when it comes to long COVID claims.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.